Hi there, welcome to Plan to Protect with Melodie Bissell, the safest podcast on the internet. My name is Joshua Bissell, and I'm the editor of this weekly podcast, where we tackle topics around safety with a focus on vulnerable sector protection and abuse prevention. I hope you enjoyed today's podcast, where we're going to be talking about power differentials.
You may ask what the topic of sexual harassment has to do with abuse prevention and how does it relate to the vulnerable sector. Over the course of the last few weeks, we've been talking about power differentials. And whenever there is an imbalance of power, influence, authority, and control, the risk of abuse increases. Sexual harassment, or any form of harassment, is a form of abuse of power. A survey published by the Angus Reid Institute in 2018 found that 52% of women said that they have experienced workplace sexual harassment at some point in their life. Yesterday, in the Toronto Star, a report was made that in the past year, in 2019, the TTC had received 42 complaints of sexual harassment by coworkers. This is an increase, double increase, over their average of between 19 to 24 reports annually. In 2017, the City of Toronto reported on polls that 43% of women and 12% of men have been sexually harassed at work. These numbers are exponential, particularly considering that most acts of sexual harassment never go reported. Sexual harassment is a behavior characterized by engaging in the course of vexatious comment or conduct that is known to be unwelcome. A seeming trend of reported sexual harassment allegations have been that of a power imbalance between employees and leadership. Seldom do we see organizations with members all of equal power, which thus poses the risk of there being an imbalance of power, manipulation of power from an individual in authority or leadership towards a staff member or volunteer. I really want to thank Amanda Kelly, who conducted research on this topic. I want to thank Tellius Law, who also provided content for our blog and our podcast. We read stories of Harvey Weinstein, Matt Lauer, Al Franken, and the list goes on and on. High-profile sexual harassment allegations have shaken up Hollywood, media, and politics. This trend is not limited to celebrities. We also find it within our own communities and within the faith community. Individuals are then left questioning if the burden of proof is met when the party with the burden convinces the fact finder that there is greater than a 50% chance that the claim is true. I remember working in a law firm in the 1970s where we had approximately 28 lawyers on staff. I knew of 22 of those lawyers that had affairs in the workplace or had been accused of sexual harassment. Sexual harassment by employers, if not dealt with swiftly, can create a really toxic work environment, as well as land even the smallest organizations in court and in hot water. In our blog this week, I did share an article by Tellius Law where they provide 10 easy ways to end up in court over sexual harassment. I encourage you to read that blog. Topics in this what not to do list are examples taken from actual cases in court. While these scandals within the faith and entertainment community have become somewhat of a hot topic, organizations of all sizes must recognize that abuse can happen anywhere and that they have a legal duty to provide a safe environment, an environment free of harassment of this form of a risk. Organizations can be found vicariously liable based on the failure to either have taken reasonable steps to avoid the harassment from occurring or to meet its duty to respond to the reports of harassment that arise. Does your organization have an anti harassment policy and procedure in place? Are staff and volunteers adequately trained on human rights? How does the organization deal with reports of harassment? Are staff and volunteers supervised to ensure that they are free of harassing behaviors? Is there a whistleblower policy in place to encourage staff and volunteers to report suspicions and allegations of abuse without repercussions? Is there reprisal for reporting or falsely reporting? As a church or organization, it's really important to exercise reasonable care to prevent and correctly prevent any sexually harassing behavior, and to document all disciplinary action or actions of employees who unreasonably fail to take advantage of any preventative or corrective opportunities provided by the employer to avoid harm themselves. Today, I'm going to speak of 4 ways that you can prevent harassment or at least reduce the risk of harassment being part of your environment. First off, I want to encourage you to define harassment in your policy. So take an opportunity to look at your policies and your procedures. Have you addressed the topic of harassment? Make sure that people know about this policy, so the content should be also communicated in training. Having a sexual harassment policy that the organization does not condone harassment, it's a good start, but it does little to help the organization if its employees don't know that it's present, or if the policy sits in a shelf or in a file drawer somewhere and is never communicated and distributed to the employees and the volunteers. In some cases, courts have held that the fact that the employees did not know about the policy meant that the employer did not make the policy available to them and did not take appropriate steps to prevent harassment from happening. Sexual harassment is a type of harassment that relates to a sexual nature and the unwelcome or inappropriate promise of rewards in exchange for sexual favors. Sexual harassment includes a range of actions, from mild transgressions to sexual abuse or assault. Harassment can occur in many different social settings, such as the workplace, the home, the school, churches, etc. Harassers or victims may be of any gender. Sexual and emotional harassment of employees, co-workers, volunteers, congregation members, adherents, or vendors is not permitted and will not be tolerated. That's exactly what should be communicated in your policy. Sexual harassment can include unwelcome sexual advances, comments, innuendos, requests for sexual favors, verbal, visual, physical conduct of the sexual nature. This can occur when there is an imbalance of power, authority, influence, and control. It's used as a basis for employment decisions affecting the harassed employee. The harassment has a purpose or effect of unreasonably interfering with an employee's work performance or creates an intimidating, hostile, or offensive work environment. Just a few examples of sexual harassment include, but are not limited to, unwelcome remarks, jokes, innuendos about someone's body, their dress, or sex, persistent leering or whistling or suggestive looks, unnecessary physical conduct as touching, brushing against someone, grabbing, pinching, pressing up against them. Unnecessary physical conduct include unwanted touching, derogatory language and or comments towards women or men, depending on the circumstance, sex-specific derogatory names, intimidation, threats of reprisal if personal relationships or sexual advances are rejected, bragging about sexual prowess, questions or discussions about sexual activities, requiring an individual to dress in a sexualized or gender specific way, paternalistic behavior based on a gender which a person feels undermines their status or position or responsibility, blaming the individual for turning them on or dressing in a way that makes it impossible for them not to respond in this way. Other forms of harassment would include racial, psychological, or spiritual harassment. So the first step is to have a policy and to make sure you communicate that policy to your staff and volunteers. The second tip we would give to you today is to really provide a procedure for employees and volunteers to submit their concerns, a whistleblower policy. Annually conduct an unbiased audit to your policies and an unbiased investigation when concerns are raised. One key procedure has to be a system to allow employees or volunteers to report harassing concerns and conduct. If the policy is not clear and people don't know how to report it, or reporting is too difficult or embarrassing when they don't report, the company is going to have a harder time making an argument that it was the employee's responsibility or fault when there is an incident of harassment. Tellius law says investigating allegations of sexual harassment is a good idea and can help the organization set up a good defense to a later legal claim. But mishandling that investigation and not taking appropriate corrective steps to address any concerns could end up causing liability for the employer. You can easily mishandle the investigation by assigning someone who is biased in favor of the person accused, who is too low level to hold accountable the person that has been accused, or who just doesn't know what he or she is doing. The third tip is when complaints are raised, take it seriously. Not only have a whistleblower policy, but investigate every single claim that you receive. When an allegation or complaint is raised, investigate it. In a he said, she said scenario, make sure to get all the facts and give both the alleged victim and the alleged offender the chance to tell their story, to be able to present evidence. When you are investigating, your role is not to determine who is lying and who is telling the truth. Your role is not to determine guilt. Rather, is a preponderance of evidence in favor of one side or the other. You're only determining if there's a 51% chance that the harassment is accurate. If the balance does not weigh in favor of the complainant, document it and validate their concern. Protect the identity of both the victim and the accused. Ensure that it is safe moving forward for both parties. Don't insist the complainant has to report or confront the accused. If the balance does weigh in favor of the complainant, document it, and swiftly initiate progressive steps of discipline. My last and final tip does relate to exactly that, progressive steps of discipline. I believe it is imperative to have a zero tolerance for sexual harassment. That would mean that individuals that are immediately let go if they have engaged in any form of sexual harassment where it has been found that there is substantial evidence that the harassment occurred. If there is enough evidence that indicates that the harassment did occur, depending on the severity, you may need to skip many of the steps of the progressive steps of discipline and immediately move to suspension or termination. At the least, if there was some form of sexual harassment, there should be a written warning on the record and a requirement for counseling and further training. Progressive steps of discipline include a verbal warning, written warning, suspension, and termination. However, skip the verbal warning, immediately document it. And depending on the severity, again, I'd encourage you to embrace it, zero tolerance for harassment, and move to suspension or termination. Don't just offer sexual harassment training when allegations and concerns are voiced. You must document it, follow up on it swiftly. I know of an incident where the female was let go and told, you know what, this is probably not an environment for women to work in. These are all very harmful comments to make. Don't just say to an individual, oh, well, he's of a different generation and he's just teasing you and you should take it as a compliment. This woman had been subjected to horrendous harassment over a long period of time by the men in her workplace, including her own supervisor. Even suggesting someone resign because they feel uncomfortable is a harassment behavior in itself and could land an organization in court with very, very hefty fines. Voicing opinion that women don't belong on staff or on a board is discrimination. Tellius Law shares one case that a court decided that a jury could conclude the employer created a hostile work environment by, among other things, denigrating a woman's role in the workplace. Don't engage in conversations where people joke about how individuals treat colleagues. In many of these recent high-profile cases that we read about and listen to on the television, says that it was an open secret, meaning everyone knew about it, that female colleagues were sexually harassed. Yet organizations did nothing to change the reputation that some of these individuals had. They allowed it to happen. They accommodated that behavior. Failure to address these issues of harassment when it occurs can come back and haunt an organization, especially when everyone knows that it is prevalent. Tellius Law also reminds us not to have within our organization a code of silence, or what happens in the lunchroom stays in the lunchroom. Abuse and harassment can happen anywhere. It's time for policies and procedures and actions to reflect this and to make efforts through practice to repair the reputation that has historically been set out by so many organizations. There is a power differential in every organization. That is important to have policies, procedures, whistleblower policies in place to address harassment when it occurs. Enhancing procedures to supervise leadership or outlining an internal process for handling reports of harassment may not guarantee a harassment-free environment, but it certainly is a good place to start. I want to really encourage you to look at your protection policies, broaden the scope of those policies so they're not just in relation to children or young people, but consider the imbalance of power that is found in every organization and write policies and procedures to protect those that are vulnerable to an imbalance of power, authority, influence, and control. Next week, we are going to be discussing a case study that has come up in the last year, and we're going to talk about that case study, and we're going to explore what was done correctly, what was not done correctly, and how we can avoid situations like this in the future. This podcast has been sponsored by our Policy and Consulting Division at Plan to Protect. Every year, we write hundreds of policies, customize them on behalf of our clients. We write procedures. We help you strengthen your policies and procedures within your organization. Another service that we offer is a policy review and gap analysis. We take your policies, we review them, we compare them to the best practices that are provided by our advisory council and Plan to Protect, and we provide you an in-depth report with recommended wording on how to improve your policies. This is a service that you're interested in, or if you would like help in customizing policies for your organization, please reach out to us at info@plantoprotect.com. We are here to help you raise the bar of protection in your organization. Now, before you sign off, make sure you subscribe to our podcast and ask to be reminded every time that we post a new podcast. We love having you as part of this podcast. We'd love for your ideas on other topics that we can address. If you find this podcast helpful, please comment below. We'd love to hear from you. Have a great day, everyone. Bye.